If you're concerned about facing a sentencing hearing, we really think it's important for you to begin preparing. And the way to prepare is to develop an understanding of the history of how judges are going to interpret sentencing guidelines, how prosecutors will try to use those guidelines against you if you are a defendant. The more you know, the better you can prepare. My name is Michael Santos, and I am with Prison Professors. As you can see here on the screen, and I'm looking over here to the left of my computer, or it might be on the right, depending on how I edit this thing. I'm going to be reading an article for you that we created specifically about the basics on U.S. sentencing guidelines. And we want to thank you for registering for this program. If you had to register, we produce this all over the internet because we really believe in helping people who want to help themselves. I did 26 years in prison. You're going to learn a little bit about how this would have helped me and how it can help you. So we're going to start off with a template here that just says any person facing a sentencing hearing should learn the basics of the U.S. sentencing guidelines. An understanding of the guidelines can help a person prepare for leniency. The resource below guides our consulting process. We believe so strongly in the importance of preparation that we offer the information freely to anyone in our community. And if you don't want to watch this video, that's fine. You can just download, or we're already sending you the PDF. It's also available in the sidebar of this argument, along with many other articles that you will find of value. Our team knows a lot about this system. In fact, our motto is, we did the time so you won't have to. But first, let me give you the background. I am Michael Santos, founder of Earning Freedom, and our team operates a series of web properties that include compliance mitigation, prison professors, and white-collar advice. You might know my partner, Justin Papern, who's really the face at white-collar advice, and we offer this information for the people that find white-collar advice as well as the people that find our other web properties. We predicate all of our work on lessons we learned as a result of being targeted by government investigations, and that is why it should be so helpful to you. We paid massive fines, we went through lengthy terms in prison, and we strive to help others make better decisions and get better outcomes. Today's lesson offers insight into the basics of U.S. federal sentencing guidelines. Any person facing a sentencing hearing will learn from this background the basics of federal sentencing, and we offer these optional videos where you will see that I bring additional commentary that I think can help you. And we hope that our audience finds this information helpful in the quest to work toward the best possible outcomes. Too many people simply rely on their defense attorneys to get the best outcomes, but the reality is that a person really needs to be thinking about what can he or she do to really maximize possibilities for a better outcome. But first, let me give you a brief history of the sentencing guidelines. So in the past, federal judges had enormous discretion when they considered what sentence to impose upon people convicted of crimes in federal court. Same thing applies to state court. There's just been a lot of reform that people need to know about and not simply rely on their defense attorney. In fact, when a judge sentenced me in 1987, the law provided that judge with the discretion to impose a term of anywhere between 10 years and life in prison. Without meeting certain factors, the law would not allow him to sentence me to less than 10 years, but he could have sentenced me to a life sentence. And in going through the sentencing process, I learned a great deal from the experience. And in going through 26 years in federal prison, I learned a lot more. So we've built a team of subject matter experts, and we've worked with more than 1,000 people that face sentencing hearings. Together, we have created a body of work that anyone can use to work toward a better outcome at sentencing. And all of it's available for free on our website at Prison Professors or on our various other web properties and YouTube channels. Success in sentencing, like success in anything else, begins with the strategy that we teach through all of our work. Step one, we've got to define success as the best possible outcome. That's not necessarily the best outcome that we want, but the best possible outcome. Step two, we've got to document the strategy that we're going to use. Step three, we've got to put our priorities in place. Step four, we've got to create tools, tactics, and resources. And step five, we have got to execute our plan, holding ourselves accountable along the way. So we encourage all people facing government investigations or criminal charges to learn more about the sentencing process. The more a person knows, the better a person can help the attorney and advance the process toward leniency at sentencing. Remember that sentencing is only one component in the process. It's an essential component, but the well-prepared person will engineer a pathway for success at every stage in the journey. Today's lesson focuses on sentencing. And so we should have an understanding of both indeterminate and determinate sentencing, at least the historical context. So in the past, judges imposed indeterminate sentences in most cases. An indeterminate sentence means that the sentence a judge imposes doesn't necessarily correlate with the length of time that a person serves. Indeterminate sentences allowed people an opportunity to qualify for parole. In other words, a judge would impose a sentence. At some point in the future, a parole board would assess the person again. Members of the parole board would determine whether continued imprisonment served the interests of society or whether the person should serve the remainder of the term in the community under conditions of parole, a supervised release type of condition. In the mid-1980s, a series of high-profile, tough-on-crime legislation started to emerge, which really ushered in this era of mass incarceration. People objected when they read that a judge imposed a 10-year sentence, but a parole board let the person out after the person served, the time that they deemed it appropriate. So let me rephrase that. In the mid-1980s, a series of high-profile cases led to new tough-on-crime legislation, ushering in the era of mass incarceration. People objected when they read that a judge imposed a 10-year sentence, but a parole board let the person out after the person served only 2 years. And that's really the way it went when I went into the prison system. There was a parole board in place. You could get 10 years, and you might only serve 3 years, 6 months, a year, 2 years. There was no telling because it was indeterminate. Another body would take another stab at the apple. But further, with judicial discretion, the sentence lengths varied. Judges in one jurisdiction might impose a short sentence. In another jurisdiction, they might impose a long sentence. And so you had situations where people that were convicted of similar backgrounds with similar crimes, similar loss amounts or whatever, but one guy might be serving 25 years and another guy might be serving 2 years. So with all of that in disparity, legislators and leaders brought forward the Sentencing Reform Act of 1984. And it's a little bit misconcerting because it says Reform Act of 1984, but the act didn't take place until any crime committed after November the 1st, 1987. So I was arrested in August of 1987 for crimes that I'd committed when I was, when I was 20 years old. And those, because it occurred before November of 87, I was under this old sentencing system that predated the Sentencing Reform Act of 1984. So the SRA, the Sentencing Reform Act, authorized the new guidelines in 84, but they didn't take effect until November of 87. But we think of the earlier version as the old law, the SRA sentences as the new law. It's important to understand that because if you're going into the system today, you've got to have some historical context because there's a lot of sentencing reform legislation that's really going on right now. And the more you know about what happened before, the better you'll be able to advocate for yourself with this new legislation like the First Step Act and so on and so forth. But again, if you don't have a knowledge of the history, you really can't effectively advocate for yourself. So besides changing factors such as eliminating the parole board, reducing the amount of credit that a person could earn through what's called good time, and the whole nother subject matters on that. But for the most part, if a judge imposed an SRA guideline sentence, the person would serve close to the entire length of time that the judge ordered. They called that truth in sentencing. The 1987 sentencing guidelines created determinate sentences that many judges deemed to be unfairly rigid. So a determinate sentence is different from the indeterminate. Indeterminate, we had the parole board. Determinate, it's what the judge imposes basically, minus some various modifications. So some judges objected to that, feeling as though the new guidelines emboldened prosecutors to make decisions by the way that they charge a defendant. Indeed, some judges rejected the guidelines and waited for the Supreme Court to determine whether the guidelines met constitutional standards. In my own case, my judge said that the guidelines were unconstitutional. Of course, later the Supreme Court ruled them constitutional, and that changed things, made it actually permanent. In the beginning, the guidelines were actually mandatory. So judges had to impose guideline sentences. That was the law. That has since changed, which is to your favor if you're being sentenced today. So the guidelines, as they were initially drafted, completely removed discretion from federal judges. Those guidelines imposed a relatively narrow range in accordance with a formulaic table. That table has evolved over time, but it offers a lot less discretion than existed prior to the Sentencing Reform Act. Further, as stated above or earlier, the SRA removed eligibility for parole completely and lowered the amount of credit a person could earn through good time. When I went to prison, I had a 45-year sentence, but because there was more good time available, I served only 26 years. So different, there are pluses and minuses to the way that the guidelines came depending on your crime. According to the guidelines, a sentencing court considers 7 factors when determining what sentence to impose. A sentencing court must consider 1, the nature and circumstances of the offense and the criminal history of the defendant. 2, the need for the sentence imposed to reflect on 4 primary purposes of sentencing: retribution, deterrence, incapacitation, and rehabilitation. The more you understand about that, the better off you are going to be in advocating for a better outcome in your journey. And we offer a lot of information to help. The kinds of sentences available, whether probation is prohibited, etc., they got to consider the sentencing range established by the sentencing guidelines, any relevant policy statements promulgated by the commission, the need to avoid unwarranted sentencing disparities, and the need to provide restitution to any victims of the offense. These are really important factors. If you don't understand them, you can't lay out a plan to advance the possibility for a better outcome. So in our experience of working with more than 1,000 people that have faced sentencing, we would argue that judges treat the sentencing guideline factor as the most important of the 7 factors. A person facing sentencing should understand this reality and take steps to engineer a mitigation strategy that may influence the judge's decision. Based on our conversations with scores of federal judges, 2 of whom appeared on videos with me on our YouTube channel, we're convinced that every defendant has a duty and a responsibility to build a record that would persuade a judge on why you're a worthy candidate for mercy. And if you haven't seen our videos with Judge Mark Bennett or Judge Stephen Boo, please visit our YouTube channel, look under our course for, I think it's called Preparing for Sentencing or something along those lines, or just scroll through our website at Prison Professors. We've got them there available for free, and you're really doing yourself a disservice if you don't learn what these judges are saying about what you should be doing. As a person that served 26 years through the criminal justice system, I learned many lessons that I want to pass along to others. When I began serving my sentence, I fell under the old law. I watched as judges began to implement the new law. And since then, the sentencing laws have gone through many iterations. In fact, they change relatively routinely every year. Changes have brought benefits to people being charged today, at least as contrasted by people that came under the first iteration of the Sentencing Reform Act. So one of the big cases is U.S. versus Booker and U.S. versus Blakely. Blakely made the cases that not mandatory, and Booker had some significant influences as well. So 18 after Congress enacted the guidelines, the Supreme Court ruled again that the sentencing mandatory guidelines were unconstitutional. I still remember I was in prison at the time, got them confused. There's Blakely, there was Booker, there was Apprendi, so all of these cases really had a huge influence on sentencing. And this happened like in the mid-1990s. I was in federal prison in Fort Dix at the time. According to the Booker Court, sentencing judges used facts not presented as evidence to the jury to impose maximum prison sentences. And as a result, the legal standard applied to the facts was not the same as the facts that juries considered beyond a reasonable doubt. Remember, in a criminal case, a jury has to find you guilty beyond a reasonable doubt, and there has to be a unanimous verdict. But under the way the law was before Booker and Blakely, a judge could consider things that were by a preponderance of the evidence, meaning it was more likely than not to have occurred. But that's kind of an arbitrary decision. You didn't have 12 jurors making that case, and of course, but other factors occurred as well. So the judge can now consider relevant conduct, which are things that you didn't even get found guilty of, but maybe has some influence in sentencing enhancement. So there's just really a plethora of complications that you've got to be recognizing as a defendant if you want to mitigate your term. So another important outcome of Booker is the requirement that the sentencing judge imposes a sufficient but not greater than necessary sentence to meet the purposes of sentencing. So theoretically, sentencing judges should impose the lowest sentence possible that still meets the purposes of criminal sentencing. Well, if you don't know about all of these nuances of sentencing, how are you going to build a strong and powerful personal mitigation strategy? In our experience, a defendant has a lot of work to do. In fact, a defense attorney may make an argument on why a person may warrant leniency, but every individual must rely upon strong critical thinking skills to advance his candidacy for leniency. In our view, a person should approach sentencing as if he is about to make the biggest sale in his life. He's striving for mercy, for liberty, and with such high stakes, he should prepare. And for that reason, we create massive amounts of content to help. And of course, we have a full team of mitigation experts for those who want to hire us. But if you can't afford to hire us, use our free stuff. So, offense levels. The first step in applying for federal sentencing guidelines is to select the guideline for each conviction. The United States Sentencing Commission provides a statutory index that lists the guideline applicable for most federal crimes. In other words, those involved compare the offense to the statutory index to locate the applicable guideline. If the exact federal crime is not listed, the U.S. Sentencing Commission instructs probation officers, prosecutors, and the judges to use guidelines that they consider to be the most analogous offense. If a discrepancy exists between the offense listed in the plea agreement and a conviction, those involved should use the more serious crime to determine the sentencing range. A defense attorney, of course, may present a case showing what he or she believes to be the appropriate guidelines for crimes not specifically covered. The guidelines generate a sentencing range. The determining factors include a base offense level and a criminal history score. Each of those factors includes a score that shows up on a grid with an x-axis and a y-axis, known as the sentencing table. The base offense level reflects the seriousness of the crime charged and shows up upon the y-axis. The criminal history characteristic reflects the number of prior convictions for the defendant, showing up on the x-axis. I can see how complicated that sounds, so what I'm going to do is really break this video here. I'm going to create a graphic that I can use to kind of help explain this x-axis and y-axis factor and the sentencing range, because you deserve to know. My name is Michael Santos, and I'm with Prison Professors, and our entire team really stands behind you, striving to provide you with good tools and resources and tactics that you can use to advocate for yourself. So let me pause this video. It's going to stay on if you're watching one of these webinars, but because I want to create a graphic specifically for you. So I'll be right back. I made this graph for you. You can see it on our website. It's part of the page, but if you're just watching this video on a webinar and you don't want to continue watching the video, just download the document and you can see everything that I'm producing right here. one of the things that I produced while I was on a little bit of break is this visual of what the sentencing guidelines table looks like. And you can see that up there on the top, that's one of the axes, the criminal history characteristics, COL I call it. And the numbers that show up on this horizontal scale up here, what they mean is that's representing how many times the person's been involved in the criminal justice system before. You got 1, 2, 3, 4, 5, 6. If you're watching this on a video, if you're listening to this on audio, then visit us at Prison Professors. But what these numbers reflect is your criminal history score. Any type of problems with the criminal justice system in the past can have a relationship here. So you want to know about that. Here we have the different zones, right? Zone A, you qualify for home confinement. Zone B, same thing. Zone C, a non-incarcerative sentence. But these issues down here are this is the vertical table, which means the base offense level. And that is 1 through 43. And you see to the right of them, those are the sentencing ranges. So if somebody had a category 17 base offense level with category 1 criminal offense history, that person would have 24 to 30 months. But if he was in category 2, the guidelines would be 27 to 33. Whatever these guidelines are, though, they're only, advisory. The judge starts from that premise. You have the obligation and the responsibility, in my view, to work towards showing why you're worthy of a lower sentence. That's really what I want to help you do here. Now we're going to talk about specific offense characteristics. So another factor to be thinking about at sentencing is a term called specific offense characteristics. Probation officers, prosecutors, and judges also consider these specific offense characteristics, we call them SOCs in our work here, when evaluating where the conviction falls within the sentencing table. These additional aggravating factors typically consider the effects the defendant's crime had on victims. Some examples of SOCs for white-collar offenses include whether the defendant abused a position of trust with the victim, whether the crime created financial hardship, and whether the defendant created more than 10 victims. Other factors might be how old the people were, or if you use the telephone. I mean, there's all kinds of things to build this up. Probation officers and prosecutors will consider dozens of SOCs when advancing their arguments to impose a harsher sentence. Likewise, a person facing sentencing should build that stronger case for leniency and show why you're worthy of mercy. Using the crime of embezzlement as an example, the base offense level is only 7, but one potential SOC is the amount embezzled. The guidelines provide for a 14-level enhancement if the defendant stole $1 million. The amount stolen will influence the base offense level. In this example, the defendant's offense level became 21 after applying the specific offense characteristics. Sentencing guidelines range is, again, that intersection where the criminal history score and the base offense level score interact. So, I really believe that a person facing a sentencing hearing should understand the process of preparing and how those preparations will influence the potential sentence. For example, step 1, a defendant should invest the time to learn about sentencing history and strategy to influence a judge's decision. Step 2, a defendant should document a strategy he or she will use to build a case for leniency. Step 3, a defendant should anticipate what the probation officer will say in the PSR and what the prosecutor will say at sentencing. Step 4, a defendant should work deliberately to make the best possible case for leniency. And this can't be boilerplate. It has to be specific to you. And no one can do it but you. You can hire subject matter experts. You can do your research. You can learn as much as possible. But at the end of the day, you've got to do it. And, we want you to get yourself ready. Step 5, A person should understand what transpires at sentencing. A judge will go over discrepancies in the PSR, then the prosecutor will argue to make his a point, and then the defense attorney is going to argue the opposing point. A judge is then going to make a finding on every discrepancy between the prosecutor and the defense attorney. Now, you should anticipate that in most cases, judges are going to side with the prosecutor, but after the judge makes a finding on the appropriate guideline range, the judge will listen to an argument by the prosecutor on the government's recommendation. Then the judge will ask the defense attorney to make an argument, and the defendant may present his own argument. So there's also something to be understanding about the zones A through D on the sentencing table. As a result of several Supreme Court rulings, judges have way more discretion to depart from the guideline range. So for that reason, our team cannot emphasize strongly enough the importance of preparing before the sentencing hearing. Every person needs to create a personalized mitigation strategy. That strategy should advance the candidate for leniency. Now, our websites and YouTube channels offer an abundance of free information to help you. But we recommend that each person facing a sentencing hearing invest the time and energy to learn how some people get non-incarcerative sentences, even though prosecutors ask for years in prison. Now, here's a little secret. No one is more important to a judge than you. You are the one that's going to move the needle here. Don't think, oh, I've got the best attorney in the country. I've got this. You've got to do your work. For that reason, a defendant should not expect the defense attorney to do all of the work. No one should work harder than you to prepare for leniency and mercy. Because the sentencing table's the sentencing table's offense level has 4 different zones, zones A through D. And determine which zone a convicted defendant's sentence falls into, the probation officer, the prosecutor, the defense attorney will all consider various factors. And the parties may consider mitigating or aggravating factors. But that determination, that assessment, that ultimate determination is going to determine whether the range is a zone A, which could include sentences of probation or home confinement or community service. Zone B, a little bit more severe, but still possibilities for a non-incarcerative sentence. Zone C, same situation. But then Zone D offenses are theoretically not supposed to get probation or home confinement, but we have met people where judges have issued a non-incarcerative sentence, even though they were supposed to, according to the guidelines, according to the prosecutor's recommendation and the probation officer's recommendation, and in some case, even the defense attorney recommended prison, but the judge gave the person a lower sentence because the person did a strong mitigation strategy. So there's a grouping of guideline sentences. If there's many different types of sentences, they may group them within these sentencing tables. The prosecutor will, there's going to be a possibility for departures and variances. And the sentencing guidelines encourage downward departures only in the following circumstances: if the victim provoked the defendant's offense, if there avoidance, coercion, aberrant behavior, diminished mental capacity, the defendant voluntarily admitted to the offense. These are factors that can warrant a downward departure. And yet the guidelines encourage upward departures in the following circumstances: extreme conduct by the defendant, unlawful restraint or kidnapping, extreme psychological injury to the victim, endangering the public welfare. But even with all of those things, we don't work with many people that have those problems, but even in situations where those factors may be applicable, the guidelines discourage any departure for the following reasons, because they're common for everybody. If the person's old or young, has an education, doesn't have an education, skills, their contributions, employment, they're going to miss their family, they found Jesus. Those types of things generally don't move the needle. If you want to get a lower sentence, you've got to think critically. You've got to use all of your critical intelligence, and you've got to understand what has worked for other people. What can work for me? What can I do to advance the ball? That's why you've got to have strong critical thinking skills. Some additional adjustments under Section 3553A include the following. After the judges make a guideline range, they're going to consider these factors: the circumstances and nature of the particular offense, the specific defendant's characteristics and history, the necessity of avoiding unwarranted differences among sentences for defendants convicted of similar conduct who have similar records. 4, the societal need for the sentence imposed. 5, the kinds of sentences available. 6, the importance of providing restitution. And 7, any relevant policy statement by the Sentencing Commission. So let me just follow with this conclusion, and that's I'm not a lawyer. Although we work with many lawyers, we view our strength is that we're giving you personal experiences. In my case, I'm a person who made horrifically bad decisions after my arrest and before sentencing. Despite knowing I was guilty, I chose to go to trial. I took the stand. I lied on the stand. And in making that decision, I failed to consider how my lawyer's interests may have differed from my interests. Not everybody has a great lawyer like I hope you have. I had a lawyer that was trying to, remove all the funds from my pocket and put them in his pocket, and he was really skilled at that. But I hope you have a lawyer that's genuinely advocating for yourself. Either way, you've got to learn what you can do to prepare. My bad decisions put my liberty on the line, and more bad decisions that I made after my arrest exposed me to a sentence that was far longer than I would have served if I had prepared better. So we really encourage anybody facing a charge to listen, learn, and ask questions. If you're facing a sentencing hearing, presents a lot of significant challenges. A person should prepare as if he or she is willing to make the biggest sale of his life. So learn as much as you can. And if your attorney is discouraging you, like my attorney did, of asking questions that will help you understand, I would say that's a red flag. You need to be thinking about your own future and what you can do. You need to be watching those videos that I did with federal judges who talk about the importance of you as a defendant. You are the most important factor in your sentencing hearing, and if you don't do everything within your power to prepare, you're really doing yourself a disservice. Now, certainly, I encourage you to visit us at prisonprofessors.com or any of our web properties if you're facing challenges with the criminal justice system. We have a huge team, and that's really our strength. We've got, all kinds of people on our team that can help you. You can book a free appointment for a consultation, or you can just educate yourself. Visit our website, and I will personally give you some free gifts of books that I wrote to learn how to prepare to emerge successfully. My name is Michael Santos, and on behalf of our entire team at Prison Professors, I want to thank you for being a part of our community, and I do wish you the best possible outcome.